Allison Taylor is counsel with law firm Stringer Brisbin Humphrey in Toronto. She spoke with us about effectively managing employees on disability leave. What are the first steps an employer should take when managing a disability leave?
The most important thing really from the beginning is to ensure that you have adequate medical information. A lot of the time employers are very shy of trying to obtain information, largely because of privacy considerations. But at the end of the day, an employee has an obligation to demonstrate that he or she has a legitimate reason for being off work, number one. And number two, if the employer is also the payor, then the employee has to demonstrate that he or she has the entitlement to be paid while off. The other thing I think that's really important for employers is to make sure they stay in touch with their employee. It's much better to have contact from the beginning, not invasive, not bullying, but contact that says we're interested in having you return, keeps the person in touch with the workplace.
What are some of the legal implications an employer should be aware of?
After a long period of disability, there's a point at which an employer may be able to take the position that there's been a frustration of the employment contract. Now, frustration is just a standard contractual concept. In the employment context, what that means is that if an employee is unable on a permanent basis to fulfill the job duties for which they've been hired, the employer can terminate that employment contract without further obligation, and the parties just part ways. This is a situation that you want to examine when a person has been off for a significant period of time, normally more than the 2-year own occupation part of the LTD policy, and in addition that the medical evidence is there, because you can't use frustration of contract just because the employee says that they're never coming back or that they're permanently disabled or because your last file note says that. It's got to be up-to-date medical information that's definitive that the employee will never be able to return to work in any capacity. The other consideration that runs in tandem with that is the fact that you have an obligation to accommodate under the Human Rights Code. So if you have a disability situation where it's a recognized disability under the code, the obligation is to return the employee to work if possible, to perform the essential duties of the position with accommodation if it's possible to do that.
And what are the main things employers should really keep in mind to effectively manage employees on disability leave?
I think there are a couple of points to keep in mind. One is the tendency to rely too heavily on one's insurance company. You can't rely on your insurance company exclusively because ultimately you can't go to court if you're being sued or if there's a human rights complaint against you and say, well, I relied on my insurance company. The obligation to accommodate is the employer's. The obligation to ensure that the employee is being treated fairly in connection with a return to work or a constructive dismissal argument is the employer's. So you can't rely on your insurance company as a defense. Another consideration to keep in mind is the fact that if you're going to challenge a claim, you should challenge it earlier rather than later. It's really no good to have an employee go off having surgery and a year and a half later they're still not back and you don't even have a medical note to demonstrate that they ever had the surgery in the first place. You know, and that happens more often than you would think. What you have to do then is wildly backpedal to go back to the beginning and say, well, let's start over again and sort of see what the progress was. That's not the right way to do it. And the final thing is that sometimes people who go off on disability are horribly unhappy in their jobs, and they really just want to get the heck out of there. And sometimes the best way to resolve their problem, knowing all of this complicated management that's required and accommodation obligations, is to see whether that really is the employee's goal. By that I mean a negotiated termination. That doesn't mean that you terminate the employee and then negotiate afterwards, because once you terminate, it's done and it's a human rights violation and various other things. But if you approach an employee in the right way and you say, you know, we're happy to accommodate you, we'll return you to work, this is what we suggest, but you might prefer to depart, and if you do, this is what we're willing to offer you. It's surprising how much of the time employees really appreciate that and will take that option in order to get a fresh start in life.